Hello, everyone. My name is Kimberly. I'm the publisher of Macaroni Kid College Park, Macaroni Kid Decatur, and Macaroni Kid East Atlanta. And I love what I do. And I've rounded up two experts who love what they do. And they're going to walk us through every single step that they can via this recording. However, if you do have questions going forward or afterwards, you can email me at kimberlywright WRIGHT at MacaroniKID.com, or the ladies will give you the email addresses to contact them directly. But we're all here to help you in this safe and loving environment. And we want everybody to know what's going on so that you don't have to use a GoFundMe. Nothing's wrong with them, but planning ahead helps you not put your business on blast that you weren't financially ready for this or that or the other. um, I personally feel like GoFundMe's are used for anything and everything, and we don't want them to be used for this thing. Like if you're in a tragical medical situation, in my opinion, that's okay. But for this, everybody's going to go through this. So why not head it off and make a plan? Come up with a fantastic plan to uh, help take care of your final wishes. First up is going to be Whitney Knox. She's a attorney, and she had a company named Wheels for the People. And then our second up is going to be Allie Murray McCrae. She's a licensed funeral home director, and she has been in the business for years, as well as Whitney. So again, I am putting you in the hands of both of them. I know that you'll learn a lot during this call, and we'll take questions at 8 o'clock. So if you want to type your questions in the chat so that we can see them, then that's great. If you want to wait to 8 o'clock and we'll call on you one by one, that's fine too. Zena, I mean, not Zena, Whitney.
Thank you, thank you. I am grateful to be with you all this evening. We're gonna jump right in. As Miss Kimberly stated, my name is Whitney Knox, and I am an estate planning attorney, also handling probate. For those who are joining a little bit late, we are recording this so that we can send it to the people who registered but are not able to attend. So you are welcome to participate by asking questions in the chat. Just know that it's not necessarily private, basically. All right, so what we're going to learn today during at least my section, and I'm going to speak for about 35, 40 minutes, and then invite Allie to share, and then we will open it up for answering the questions. So what I'm going to be speaking about is why estate planning matters, why planning can change during the different stages in your life and in key moments, and then what next steps are to make sure that you're getting your affairs taken care of. Within this conversation, we're also going to be talking about probate and what is probate like and why might people want to avoid having to go through a probate process. So again, I'm the founding attorney of Wills for the People. I started my practice in 2024, and we were just nominated as one of the best estate planning attorneys in Georgia. We're really proud of that and appreciate your vote if you are somebody who likes to do that type of voting. Um, I went to law school at Seattle University School of Law, where I grew up in Seattle. I've been a practicing attorney for 12 years and have spent my entire career practicing out here in Georgia. So, first things first, when we say estate planning, what are we talking about? Estate planning is less about you and more about your loved ones and making sure that your loved ones are taken care of, that they have direction. If you are incapacitated and you're not able to make decisions for yourself, or after your death, if you have passed away and now your loved ones need to figure out, okay, how are we going to fill this hole that you have left, primarily in this case, financially, and relating to property, but also in relation to care for any minor children or dependents. One thing that I want you all to ask yourself as we go into this conversation is, if you died or became incapacitated tomorrow, what is going to happen to your family? Some of us are the primary breadwinners in our family. Some of us are the primary caregivers in our family, primary parents, perhaps. Some of us don't, maybe we are the ones that are handling like the logistics of the finances, or we are the ones that know where all the passwords are, or that know all of the appointments and the doctors that we go see. So if we pass away, not only is our family without our income, but our family is going to have to figure out how to get the tasks done that we would normally get done. So for some families, this means now they're not able to afford their lifestyle. Maybe they're not able to afford their mortgage because they're down to a one income household. Maybe they're now having to scramble for childcare because the person who was the primary caregiver of the children is no longer alive to be able to do that. So estate planning is about making sure that if something happens to you, your family has direction for what they can do in order to alleviate their suffering, in order to feel as though they have some control over the situation, in order to save themselves some money because it is costly to pass away or to become incapacitated without having to plan. Okay. So if you could do something today that you knew would alleviate the suffering that they will experience after you've passed away, or if you become incapacitated, would you? And a lot of us would. I would. And so we're going to talk about some things that you can do that involve an attorney, but also things that don't involve getting an attorney, because there's a lot of things that you can do today, right now, or during business hours tomorrow that do not involve paying an attorney to be your advocate. All right. So why do we plan? Why do we have estate plans? I've broken this down into 4 primary categories or goals. 1 is to prepare for our life events. 2, to protect our dependents and our loved ones. 3, to build wealth. And 4, to preserve assets and to build legacy. My presentation is going to be covering primarily the preparing for life events and protecting dependents and loved ones. But I am going to touch a little bit on the tools that we use for all of these stages of planning. Let's first talk about, though, what happens if we don't plan, because that's an option, right? When I'm in person, sometimes I start my seminars by saying, okay, who in here has an estate plan? And usually less than a handful of people will raise their hands. And that's when I tell them, actually, everybody in here has an estate plan. You have an estate plan. You might not like it. You might not know what it is, but your estate plan is whatever the state says. And what the state says, if you have not opted out of their estate plan, is that when you pass away, your assets are going to be passed to specific people, namely your spouse, whether or not you like them, whether or not you are separated. If you are not divorced from that person, your spouse gets at least 33% of the assets that you leave behind. If you have children, then your children are going to share those assets with your spouse. If you have adopted children, they will share those assets with your spouse. But if you have stepchildren, they will not. Stepchildren don't count by law. Okay, so the law is going to determine who your heirs are and who gets your assets and how much of those assets that you get. And there is a hierarchy based on the relationship of that person to you. Okay, the law is also going to decide who is controlling your money, who is controlling your assets, and ensuring that the assets get from your estate to the person, the spouse, the child, the cousin, whoever it is. Your family is going to have to go through a probate process in probate court, because That is how we distribute property here in Georgia when you don't have an estate plan. And in some cases, that's how we distribute property even when you do have a plan. Okay. You're at risk of creating heirs property if you are a homeowner, because your home is going to be, if you have, in this case, maybe a spouse and multiple children, your home is going to be divided up amongst all those people, depending on how you own that property. Okay, so if you own it as a tenant in common with someone else, your share is distributed to your heirs. If you own it solely, you're the only owner, then that property, 100% of that property is distributed amongst your heirs. And if you own that home as a joint tenant with right of survivorship, then it's actually not your heirs at all who get that property. It's the other owners who now get your property. So one of the things that's really important for you to do if you are a homeowner is to take a look at your deed. If you're a sole owner, so if you're the only person, great. You don't need to look at your deed. You're fine. You know that if you pass away, either you need a will or you need a trust in order to be able to distribute that property to who you want it to go to. Otherwise, it's going to be distributed according to Georgia law. But if you own your property jointly with someone else, you should look at your deed to see how you own it. Do you own it as a tenant in common, or do you own it as a joint tenant with right of survivorship? Because that is going to determine how you're able to pass that property. Okay. I'll also say that one big thing is your heirs are going to receive any of their assets outright. Meaning, if there is a large sum of money, even we'll say $50,000 in the bank account, you have one heir, and that heir is your adult son. That adult son is going to get all 50,000 of those dollars just outright. Maybe that's great, maybe that's what you would want, but maybe that adult son has debt and has creditors suing to recover on that debt. What happens then is that your son doesn't get that $50,000. Instead, the creditors get that $50,000. So your son doesn't actually get to benefit from it. Same if you have property and you want to leave property to that son, but that son has creditors after them. That property can be swooped up by those creditors as soon as the property transfers to the son's name. So there are things that we want to do to ensure that our assets are used how we would want them to be used after we pass away, or at the very least, that our assets are being can be leveraged by our loved ones instead of going straight to creditors or ex-spouses or other potential issues. Okay. What is an estate? Often we kind of remove ourselves from the estate planning conversation because we don't think that we have an estate. I am here to tell you that everybody has an estate. An estate includes everything that you own, no matter how small or how small in value, and no matter how large. So examples are your life insurance. If you are somebody with life insurance, that is a part of your estate, even though while you are living, if it's like term life, you actually have no right to get any of the dollars from your policy. So if you have a $1 million term life insurance policy, then the value of your estate is at least that $1 million minus any debt or liabilities. Also, your vehicles count as part of your estate, your home, any intellectual property. If you are a artist or you are an IT person and you develop, I don't know, apps, that is intellectual property and that is part of your estate. Importantly for this conversation, since we're having this for parents of kids, children, and guardians, is your children. Your children are not, I would not call children an asset. They are not a thing. However, children are considered part of your estate as far as estate planning goes. because it's through estate planning that you are deciding who is going to be the legal guardian of your children if you pass away while they are still minors or if you become incapacitated. I have been talking this month a lot about planning for minor children because, particularly here in the South, we love to bestow upon our loved ones this honorary position of godparent. Godparents don't mean anything under law. Like, they're great. Godparents are great. I have godparents. I have god siblings because my parents are godparents. But godparents don't mean anything if the actual legal parents have died. All it means is you've got a great name. So we have to actually take steps to make a godparent a legal guardian if we need them to be that. And we're going to talk about those steps today. All right, so your estate plan is a strategy for how you are going to make sure that your assets and your legacy and your children are protected how you want them to be. Important to note is that what you need and what your goals are going to be are going to change as your family goes through different stages of life. So when you are preparing to have a family, maybe you are an expectant mother or you're getting ready to adopt a baby, your considerations for how you need to have your estate plan set up is going to be different than if you are an empty nester. Because at those phases of life, you're considering two totally different things. At one stage, you're considering, how do I keep my minor children safe? How do I keep a roof over their head? How do I keep them fed? And when you're an empty nester, you're thinking more about, okay, I'm at the end of my working years. How do I make sure that there's enough money for me to be able to sustain the rest of my life? So considering all of the different aspects and phases of life, I've created this chart that just kind of shows in a kind of briefly, because it really doesn't capture the complexity of life, but it shows some of the stages that we might experience throughout our lifetime. So as far as age, we start out young, we grow older, right? When we think about events in our lives, major events that happen that may change how we plan, we can think about business ownership, becoming an entrepreneur or a business owner. We can think about our income. There are times in our life where our income is going to grow, and then there are times in our life where our income is stagnant, and then there are times in our life where our income may diminish over time, or it may be fixed over time, right? Like if we are receiving a retirement benefit and we know every month we're getting $2,000 and that's it. When we become owners, that's a significant event that should cause us to consider whether or not our estate plans that we currently have in place are still good for what we want to happen, or if we need to make changes to that. And then I already mentioned income being stagnant or decreasing. With our health, of course, there are times where we have good health. There are times when our health isn't so good. But also as we age, maybe we're facing new illnesses, or maybe we are injured because there's a car accident that's happened. And now we're not able to earn the income that we were once able to earn. Or maybe we become disabled and now are receiving government benefits. That is very significant in the world of estate planning, because in order for you perhaps to receive those benefits, you have to have under a certain amount of income. Or like myself, one of my children was diagnosed with autism when he was young, when he was 18 months old. We didn't know at the time whether he was going to be disabled in the way of not being able to care for himself. Looks like he'll be fine and be able to care for himself. But if not, we were going to need to start planning for, how do we get him services without our income counting against him? Because there's lots of services that disabled individuals need And there is government support for that, but it does require that you have limited access to resources. So when you have a family that has a disabled individual, it's important that you are speaking to an estate planning attorney, because there are steps that you're going to need to take in order to um, make sure that that individual can benefit from the assets of the family without being disqualified for some of the services that they're going to need long term. And then frailty. In fact, most people die not from sudden deaths, but they die from old age, and they die from chronic illnesses. And if you are 60, if you reach the age of 65, then you have a 70% chance of needing long-term care in your life, okay? And long-term care is incredibly expensive. And so when we think about that expense, that is something that we have to plan for. We plan a lot for retirement. We don't really plan at all for healthcare in retirement. Okay. And then finally, your family circumstances are going to change. So you're going to get married, you're going to get divorced, you're going to have breakups, you're going to have long term partnerships. You may or may not have children. Those children may be biological children, or they may be adopted children. They may be stepchildren. You may have a blended family. You may relocate from one state to another state. That is an important consideration, because estate planning laws in every state are different. So if you have a will in Georgia, but you relocate to Washington State, you may need a new estate plan simply because Washington State may not acknowledge the validity of that Georgia will. Okay. And then, of course, we all die. Death is certain. It's not certain when, it's not certain how, but it is certain that we will die. And so planning for that death, planning for what do you want your final days and weeks to look like? Do you want to pass away in your home? Do you want life support? And to what extent do you want life support? Who's going to pay for all of these extra services at the end of your life? Is that going to come out of your estate? Or do you just want to, I don't know, have the plug pulled so that maybe those resources can go towards your loved ones or your families? All of these are things that you'll want to think about, and all of these are happening together. And as they change, our priorities as far as how we plan is going to change as well. So here are the primary components of an estate plan, and there are a lot. Not all of them are things that an estate planning attorney is going to deal with. For example, insurance and retirement. That is something that you'll want to see a financial advisor, an insurance agent about. Okay. We are going to talk today about just a few of these, namely the last will and testament and the revocable trust. Okay. So earlier, I talked about the 4 phases or the 4 goals that we have when we plan. Preparing for life events, protecting dependents and loved ones, building wealth, and preserving assets to build legacy. These pie charts are just to show how at different stages in your life, maybe you're thinking more about one of these areas. Maybe you're thinking more about preparing for life events than you are thinking about preserving assets. Okay, so for example, when you're young, healthy, and maybe a newlywed, you're at the beginning of your career, perhaps. You are really preparing for life events. You're preparing for what's going to happen in the future. You're protecting a little bit your dependents if you have them. I mean, they're certainly important. But like as far as your spouse goes, they're adults. Like maybe you're not quite so concerned about them. Okay. And then you don't have a lot to build on because you don't have a lot of money. You don't have a lot of anything at that point. And similarly, you're not spending a whole lot of energy thinking about preservation or planning about preservation. On the flip side, when you're 62, you have adult children, you're married, maybe you have a chronic illness, and you are gearing up for your retirement. you're thinking a whole lot about preservation because you want these assets to outlive you, hopefully, but at the very least, you want them to last throughout your lifetime. So, how you plan, whether or not you have investments, whether or not you are using different types of trusts, is going to be different at this age of life than it's going to be when you are young. You're very healthy and you're married. Okay. Also, your adult children, you're no longer worried about saving for college. You're no longer worried about who is going to be the guardian of my minor child. You're no longer worried about making sure that this child has money to be able to, I don't know, get married because maybe you're more concerned about your money lasting for your lifetime. Okay, so this is why it's really important that one, we have an estate plan, but two, as we age and as the circumstances within our life change, we are also taking time to review our estate plans to see if anything needs to change within our plans. So let's talk about that first stage of preparing for life events. So there are three key components of estate planning when you are preparing for life events. There's the powers of attorney, which, in my opinion, the healthcare power of attorney, also known as the advance directive or the living will, that is the most important document of all of this. And the reason why is because you are still alive when you need somebody to use it, and you are determining who is going to have the authority to make the health related decisions that you need. Okay, so that is one of the types of power of attorney documents. There's also the last will and testament, which is the document that allows you to identify who is going to get your assets, who is going to be the guardian of your children, and who is going to be responsible for probating your estate. And then there's insurance. This covers everything from life insurance to, if you're a homeowner, having homeowners insurance. Why? Why does insurance, what does that have to do with estate planning? The whole point of insurance is giving you money so that when something bad happens, you're not going out of pocket. It's not completely destroying all of the assets that you have. So it's important that we carry enough insurance, whether that's home insurance or auto insurance or life insurance, to be able to help our families deal with whatever is going to come up, whether that is a car accident that now makes it so that our family of 7 only has one vehicle. And now both adults are going to have difficulty getting to work with that one vehicle. All right. Protecting your dependents and loved ones. Key kind of documents or planning that you can do for this stage of estate planning is having payment on death beneficiaries for every account that you can think of. If you have a bank account, just a regular old checking and savings account, one free thing that you can do tomorrow when your bank opens is go to the bank branch and let them know that you would like a payment on death designee. What this means is a person who you've identified, if you die and nobody's able to, and there's money in that account, the payment on death designee can present themselves to a bank branch and request that that money be released to them. This is vital for people who have dependents who need that money. I don't care if it's $500 or if it's $50,000. Okay? It's vital because if we don't have that set up and we also don't have a will or a trust, then that money is going to be frozen. It's going to be kept from your loved ones until a judge says that they can go and get it. And that process of a judge saying that they can go and get it can take 2 years or more. Here in Fulton County, where I am, the average amount of time for a probate is 2 years. The standby guardianship designation is a guardianship designation for parents who are still alive, but who are incapacitated and can't care for their children. Okay, so it's necessary because there may be times in life where we can't care for our children and we need somebody to be able to step up and do that. And then finally, the revocable living trust, which is similar to a will, but it allows for more control over how our assets are distributed. And it also provides asset protection for our beneficiaries. So, again, say I do have a child who is accident prone and I want to leave money, but I'm afraid that if I leave money, they're going to be sued and somebody else is going to get that money. The revocable living trust allows you to create subtrusts that keep that money safe for the beneficiary and are only distributed to the beneficiary when they're ready for it or when you say that they can have it. And until it's distributed to the beneficiary, that money is kept safe from creditors, from spouses, from lawsuits. Okay. Building wealth, we're not going to talk about this today, but this is still a vital component of estate planning, and it's dealing with ensuring that you have your retirement, your investments, your annuities, and other types of wealth building tools set up so that you can benefit from those. And then some of the tools that you can use to preserve your assets if you are maybe later in life or concerned about taxes or concerned about asset recovery are irrevocable trusts, the transfer on death deed, which is not yet ready to be used in Georgia, but which is now legal in Georgia. It allows you to transfer your home to a loved one without having to go to court. And then long-term care planning. Unfortunately, we won't have an opportunity to talk about these aspects, but there's usually a question about transfer on death, so we'll probably touch on that at the end. Okay, so going back to these 4 phases, why we plan, I'm going to talk a little bit more about phases 1 and 2, preparing and protecting, and specifically we're going to talk about the last will and testament and the revocable living trust. Because when you get an estate plan, the foundational documents that are going to be, that you're going to have are your last will and testament and a revocable living trust. All right. So your last will and testament. This is a document, like I said before, allows you to identify who's getting your assets. It allows you to nominate guardians for your children, but only after death. And then it allows you to nominate your executor to wrap up your affairs. A will can fail, though, because a will has to go through probate court. And what I mean by fail is a will, because it has to go through probate court, that means it has to essentially be approved by a judge. A judge has to say, yes, your will is good, it's valid, it's legal, there have been no challenges, your family can now move forward with what you've requested to happen in your will. However, being in court, which is a public process, opens your estate up to challenges, meaning anybody who says that they have an interest can make challenges against your estate, whether it's a disgruntled ex or a creditor or somebody who says that person was their father. Okay? All of these people can make claims against the estate, which in turn slow down the process. Wills do not provide for incapacity, so they have nothing to do with what happens if I can't make decisions for myself today. Because a will only becomes active after death, which is why that guardianship designation in the will only becomes active after death, and why a standby guardianship is still necessary for while you are living. Wills are based on state law, so they can be problematic if you die outside of the state of Georgia. And then they don't provide any kind of asset protection long-term after your death. One of the common misconceptions about wills is that having a will means that you're able to bypass probate when you want to distribute your property. That's not true. Okay, so if you have a will, your family needs to go to probate to have that will probated. And what happens when you're in probate is that the court is going to appoint the executor, so the person that you have nominated to manage your affairs. The court has to officially appoint them, and they have to take an oath. Notice of your death is going to be published in the papers so that anybody can come and say, that person owes me money and I want my money. An inventory of your assets is going to be made. The assets will be distributed. You need the court's permission for everything, and everything is reported to the judge, and you may or may not need to hire an attorney. So the major downsides to probate are that it's expensive and that it can cost 1 to 9% of the value of your estate. 1% if you don't hire an attorney, you're closer to 9% if you have to hire an attorney. Okay. Our fees for probate, my fee starts at $5,000 flat fee. Probate can be time consuming. I talked about that it can be 2 years or longer here in Fulton County. And then it's public. Anybody can go to probate court proceedings and watch. Anybody can pull some random person's will and see what they got. I'm going to skip through these slides since I know I am running a little bit long. So when might you still want a will-based plan? So maybe you are only concerned about nominating guardians for your children, or maybe you're not so concerned about avoiding probate. That's, in both those cases, that's totally fine. What I tell people is that a will is foundational. You at least need a will. But there are some people who will need more than a will. Okay? And if that's you, then a trust may be the option for you. A revocable living trust is like a will, but it's on steroids. You are able to pass your assets to people, and those beneficiaries do not have to go through probate, because a trust is a contract that you're making with yourself as the trustee of your trust. And what you're saying is, when I pass away, I want my successor trustees, the other people who I've appointed to manage my affairs, I want them to pass my assets to whoever I say. I do not want them to have to go through a probate court process. You're able to decide when the beneficiaries receive the assets, in what increments. So if you only want them to receive 10% of their inheritance every 5 years, you can say that. You're able to decide if those beneficiaries need to have completed anything, any tasks. I have clients who want their beneficiaries to have gone through a financial literacy training. I have clients who require their children have completed 4 years at an accredited college or university, or 4 years in the military with honorable discharge. Okay. You are the trustee of your trust during your lifetime. So there is no change in your ownership of that asset. And then for your beneficiaries, they can enjoy what's called asset protection, which again is that protection from their creditors or any liabilities that they might have. So the 3 roles in every trust include the trust maker, who is the person who is creating that trust, the trustee, who is the person who's managing the trust, and then the beneficiary, who is entitled to the assets within that trust. And while you are living, you are all 3 of these positions. You are the grantor or the trust maker, the beneficiary, and the trustee. What's important to know that if you do need a trust is that you must retitle the assets to your trust. I will, sorry, I'm getting distracted by these messages. Yeah, so I'm gonna wrap up my portion in the next couple of minutes. But I wanna share with you the revocable trust. So it's like a kid's backpack in that everything inside of the backpack cannot be touched by probate courts. That is able to be passed without having to get permission from a judge, as long as you have done the proper procedures for getting that asset into the backpack. And what that means for a home is actually retitling that home from a home owned by Whitney Knox to a home owned by Whitney Knox, the trustee of the Whitney Knox Revocable Living Trust. Every type of asset has a different way to be funded into the trust. And so you would talk with your attorney about how to do that. I'm going to skip that example. Okay, so a trust solves some of the problems of a will in that you're not losing so much of your asset in probate. Your assets can pass much sooner than if you had to go through a probate process. And then it's totally private during your life and after death. I talked about the guardians. If you are getting a trust, then you would also get what's called the pour over will. And the purpose of that pour over will is to ensure that if anything is not funded into that trust, that it can be treated as if it is, and also so that you can appoint those guardians. All right, I am going to end my presentation here and pass the floor to Allie. Uh-oh, there we go. Okay, I just asked you to unmute.
All right. Hello, everyone. How are you? Great information. Thank you, Whitney, for sharing. Made some notes and definitely we'll look into some of those things. I am a funeral director and embalmer here in the state of Georgia. I have been for the past 27 years. And of course, I often meet people at their worst. And of course, we're talking about final wishes. My main thing is have a plan. In having a plan for final wishes, there are some key things that you need to know. The first is a lot of people come before you with paperwork to state they are power of attorney. Power of attorney ends at death. Therefore, you don't have actual rights to a deceased. It would revert back to the legal next of kin. And I think when people get power of attorney papers, they are misinformed that they are in total charge in life and death. But of course, it ends at death. There are some other documents that you can have in place. There is in the state of Georgia a Georgia Health Advance Directive. And of course, this particular directive, I'm sure Whitney can advise you as well. It does state about your final wishes and the person that you can put in charge of those final wishes. It can also declare if you wish to be cremated and your family is against cremation, you can choose someone to do that option for you. And of course, if you're against cremation and you want burial, then you can definitely make that decision on that document. Of course, my main concern when it comes down to final wishes is definitely having your paperwork in order. One thing is a budget. Know what you are needing, the type of service, cremation, burial, traditional versus non traditional. These are all things that we have to think about because these are the questions that come up. How much? What am I going to do? What can I do? And how will we do this? Unfortunately, when it comes down to your final wishes, you have to either have money on hand, of course, credit cards, life insurance, because we're trying to avoid GoFundMe's. And unfortunately, most funeral homes will not set up a payment plan because, of course, there is nothing for us to repossess. I'm sure many funeral homes have been burned in having payment plans, trying to hear sob stories and helping people out. And sometimes when you help people out, it can also backfire on you. I remind families that at the end of the day, we do have light bills, overhead, employees that we have to pay. And of course, you cannot pay them on payment plans. When it comes down to, of course, finding a funeral home, I encourage everyone to do your research. Do your research and find out which funeral home is best for you. Of course, there are a lot of funeral homes throughout the city, encouraging you to definitely get to know your funeral director to make sure that you are getting the best service for your family when that time is needed. Of course, if you go into the funeral home, then of course, one of the services that we offer is what you call pre-planning. Pre-planning allows you to first save money. Of course, in saving money, it allows you to lock in today's costs. Let's say you come in to meet, it's a 2025 cost compared to the increase that usually occurs within every year or 2 years. Of course, I currently am with a firm where we have pre-needs that date back to the 80s and the 90s. And you're talking about families who took care of this particular pre-plan, and they're getting funerals today at a cost of $3,500, $4,500 compared to a family who would come in today as an at need and may have to spend anywhere from $10,000 to $12,000. That's a big savings, if you ask me. I myself also have a pre-plan in place. And of course, even though I'm quite sure my family may not charge me a certain amount, I still have that set, not only just to lock in today's cost, but most importantly, to make my wishes known in regards to what I would like to transpire when that time should come. There's a form that we'll be able to share with you. It's called a funeral instruction sheet. The funeral instruction sheet talks about some things as far as your wishes. Most importantly, it talks about vital statistic information. You would be amazed at how many people sit down with a funeral director and don't know some of the simple things in regards to a grandmother's maiden name or even where their loved one was born. So these are some things that you can honestly do before to be proactive. I've seen people as far as not really knowing their parents' education level of if they completed high school or some college or even went on to obtain a bachelor's degree. These things are all needed when it comes down to completing services because we do have vital statistic information that has to be completed as well. Of course, in sitting down, I encourage people to definitely know what you want. Having a meeting before you sit down with the funeral home. If you are pre-planning, to talk amongst yourselves, if it's siblings that are assisting with parents, to have a discussion, sitting down with your parents. It's not something that a lot of our parents wish to talk about. Of course, I've just buried a parent this year. And all I could remember is everything my mother said to me not to do. But she never put anything down on paper. So here I was at a table with another parent who is her spouse. And of course, siblings, and like, hey, do you remember mom said this? Do you remember mom said that? So here you are, because we don't have anything in writing, trying to recall and recant what was told to us and what we're supposed to do. The pre-planning just makes it a little bit easier when it comes down to that final time. And of course, some of your emotions, you're allowed to be able to celebrate your loved one's life versus just being overly emotional because it's all coming to you at one time. Of course, I made a couple of notes here as far as just some statistics that I was looking at when it came down to funerals in America. Um, of course, sometimes the funeral home can come off as being the bad guys. That's why I ask and encourage you to please find someone that you all are familiar with and, of course, reputable and that you feel comfortable with. But of course, America deems that the funeral home is needed. About 76% of Americans agree. I let everyone know I'm quite sure you don't want to do my job every day because it's not just the deceased that I have to worry about. I have to worry about the living and, of course, providing these services for them. So, of course, taking into consideration from caskets to urns, yes, you can come outside of the funeral home and bring your own in, but I encourage you to talk with your funeral director. I don't know that the average person wishes to purchase a casket ahead of time and keep it in their home. And usually that's the purpose of the pre-planning, so that you can lock in that cost with the funeral home and be able to have that great savings later on down the line. Of course, if you are looking at burial, I encourage you to also think about your cemetery pre-planning, because that is just as important as the funeral home, knowing where you want to have your final resting place. Of course, if cremation is the option, then at this point in time in 2025, I also encourage you to still bury the cremains versus having them at home. We get daily calls from realtors who have found cremains at someone's home where they have been left, and they can no longer get in contact with the family. And of course, we don't want to receive them back at the funeral home. And here's your loved one just being returned back to the medical examiner or the state. And it's just an honor to be able to to place your loved one to rest and have somewhere to visit. Scattering is very popular here in the United States now. There are several places where your loved one can be scattered. I've had several families to be able to have cruises, and they all go out together and they release the ashes into the ocean. There are so many different options. And I encourage people, just sit down with someone who's knowledgeable so they can share this information with you. Of course, there are some new dispositions when it comes down to final wishes. Of course, you'll have a lot of people that want to go back to the earth naturally. Of course, in the state of Georgia, we have 2 places that you can actually do that as well. Just because, excuse me, you all are going back to the earth naturally, it does not mean that it's a lesser expense. Of course, these companies do have an expense to be placed into a natural setting to go back to the earth in a natural state. They have some other ones that they are trying in different parts of the United States, the hydro disposition, where they are liquefying the remains, turning them into water. Of course, it's not approved here in the state of Georgia. I think the only place is California. I'm not sure how that will make it over to the southern states, but I'm sure we'll probably see a change within the next 10 to 20 years. Of course, these are basically the key points that I give to persons when we sit here and talk about the pre-planning, just to do your due diligence, have a budget, have a plan, make your plan plain, and make sure that we do our best to try to stay away from GoFundMes. I've seen some horrible situations with that as well. And of course, I just wish and encourage people to please take into consideration to get life insurance or to place some monies aside so that we are able to plan, leave your family a legacy. And remember that the funeral is not about the deceased, but about those that are left behind wanting to celebrate a memory of a person who has passed on. So I'm hoping that the information that I have shared with you definitely enlightens you. I'll definitely leave my email here in the chat, where if you do have any questions, you're welcome to send me a message. And of course, I know sometimes people have some messages, questions outside of our conversation here, and I'll be glad to assist as best possible.